This video is one in a series of videos on special education due process developed by the Office for Dispute Resolution, or ODR, and the Pennsylvania Special Education Hearing Officers. The purpose of these videos is to give you an overview of what to expect if you are involved in a special education due process hearing. Before we begin, please be aware that this video series addresses special education due process hearings filed under the Individuals with Disabilities Education Act, or IDEA. These are the most common types of due process hearings. If your hearing is about gifted education, Section 504, or early intervention, there may be some minor differences in your hearing procedures, especially as to resolution meetings and timelines. However, these videos should still be helpful in getting prepared for any of these hearings. For more detailed information on gifted education or Section 504, please call the Bureau of Special Education's Consult Line. For more information on due process, please visit the ODR website. Contact information is available here and at the end of each video. For additional information regarding early intervention, please refer to the Procedural Safeguards Notice. Video 1. Pre-Hearing Matters.
Hello, I'm Hearing Officer Jake McElligott. This is the first in a series of videos on special education due process. Each video in the series focuses on a different aspect of the hearing process. We've made separate videos that address pre-hearing matters, preparing for the hearing, and the hearing itself. The first video addresses pre-hearing matters. Those include an overview of due process, which includes requesting due process and scheduling of the hearing, the roles of the participants and the Office for Dispute Resolution, or ODR, important timelines, and communicating with the hearing officer before the hearing. Overview of due process. The IDEA is a federal law that sets forth the requirements for providing special education to children with disabilities. The local education agency, or LEA, is the agency ultimately responsible for providing special education and related services. In Pennsylvania, the local education agency can be a school district, an intermediate unit, or a charter school, including a cyber charter school. For most school-age children, from kindergarten through high school, the LEA is a school district or charter school. For most preschool children, the LEA is an intermediate unit. To keep things simple in this video series, we will use the term school district or school to refer to any local education agency. The IDEA requires each state to have a number of options available to parents and schools when disagreements arise about the educational program for a child with a disability or a child thought to have a disability. One of those options must be a due process hearing. Pennsylvania meets that requirement through the Office for Dispute Resolution. A due process hearing is a formal legal proceeding before a neutral hearing officer. Hearing officers are responsible for the case until it is concluded, either through settlement by the parties or by a decision. Hearing officers are knowledgeable about special education and special education law. In Pennsylvania, hearing officers are either attorneys or psychologists with doctoral degrees. The law requires the hearing officers to be impartial or neutral, meaning they do not have any personal interest in the outcome of the case. The hearing officer hears evidence from both the parent and the school. The hearing officer applies the law to the facts presented in the due process hearing, and then writes his or her decision resolving the disagreement about the child's educational program. In Pennsylvania, hearing officers actually write very few decisions. Due process hearings are only needed when the parent and school cannot resolve their disagreement between themselves. In most cases, the parent and school are able to resolve any disagreements about the child's education without a due process hearing. Many times, even after a due process hearing is requested, the parties are still able to settle the case on their own. Open and ongoing communication between the parent and school is always beneficial and oftentimes leads to resolution of the dispute. requesting due process. Either a parent or a school district may request a due process hearing. A due process complaint, whether it is filed by a parent or a school district, can address any issue regarding the identification, evaluation, or educational placement of a child with a disability, or the provision of a free, appropriate public education, or FAPE, to a child with a disability. When a parent or school district requests a due process hearing, they file a due process complaint and send it to ODR and the other party. The parties to the case are the parent or parents and the school district. The due process complaint notice is available on the ODR website and specifies what information the IDEA statute requires a complaint to include. That form is also available by calling ODR or the Special Education Consult Line. Once a party files a due process complaint with ODR, the complaint is assigned a case number and an ODR case manager. The case managers document all aspects of the case, from the beginning to the end. The case managers can also answer procedural questions about due process, but they are not attorneys or advocates and cannot give legal advice. The case manager then assigns the case to a special education hearing officer and provides the parties with the hearing officer's name and contact information. Scheduling the hearing. The case manager at ODR will send a notice to the parties and attorneys of the scheduled date, time, and location of the hearing. The hearing officer will set the initial hearing date within the timeline that applies to that case. The hearing officer is expected to set a hearing date as soon as a case is assigned, so is not able to consult with the parties or their attorneys about the hearing date before it is scheduled. Hearings are typically held at the school district in one of its buildings. Any party who needs some accommodation to participate in the hearing, such as an interpreter, should let the hearing officer and case manager know as soon as possible.
Here is a frequently asked question. What if I know I cannot be available on the date of the scheduled hearing?
Everyone, including the hearing officer, understands that a scheduled hearing date or time may not be possible for someone. If you know you cannot attend the hearing on the scheduled date, you should contact the hearing officer as soon as possible to ask that the hearing date be changed. You should also let them know the reason you are making that request. Remember to copy the other side. Before deciding whether to grant the request to reschedule the hearing date, the hearing officer may check to see whether the other side has any objection. But most of the time, the hearing officer and the parties cooperate to find hearing dates that accommodate everyone.
Timelines. Hello, I'm Hearing Officer Ann Carroll. In this portion of the video, I will be discussing timelines for a hearing and communication with the hearing officer. Once a party files a due process complaint, the initial hearing date is scheduled based upon the timeline set forth in the IDEA, depending on who requested the hearing. When a parent files a complaint, the law first requires a 30-day resolution period before the hearing may be held. During the 30-day resolution period, the parties will either hold a resolution meeting, which must occur within the first 15 days, or they may choose to participate in mediation. Or they may both agree to waive the resolution meeting and move to a hearing more quickly. All of these circumstances impact the IDEA timelines in different ways. The scheduling of the hearing varies in each case depending on what happens during the 30-day resolution period. But when a parent files the due process complaint, the law says that the hearing will be held and the hearing officer decision written within 75 days after the complaint was filed, unless either party requests an extension of time. It is very common for the parties to request an extension of time. The timelines are different when a school district files the complaint. When the school district files a due process complaint, the IDEA does not require a resolution period. So the law says that the hearing will be held and the hearing officer decision written within 45 days after the complaint was filed, unless either party requests an extension of time. Again, it is very common for the parties to request an extension of time. The hearing officer will always let the parties know when the decision must be issued, what is called the decision due date. The decision due date is the deadline to end the case. It is the latest date for the hearing officer to issue the decision. An extension of the decision due date may be granted by the hearing officer at the request of a party for a number of reasons. But even though the decision due date may change, it helps to keep the case on track and moving forward so it can be completed in a timely manner. Communication with the hearing officer. After the case has been assigned to a hearing officer, he or she is responsible for moving the case forward. After the hearing officer is assigned, he or she will contact the parties or their attorneys if represented about matters important to the case. Remember that the parties to the hearing are the parents and the school district. Parents may be represented by an attorney if they choose, or they may represent themselves. A person who represents himself or herself without an attorney is called a pro se party. School districts are always represented by an attorney. The parties or their attorneys will probably need to communicate with the hearing officer. Communication with the hearing officer always includes a triangle of participants. When a parent is represented by an attorney, communication takes place between the hearing officer, the parent's attorney, and the school district attorney. When parents represent themselves, communication takes place between the hearing officer, the parents, and the school district attorney. From the time a hearing officer is assigned to the case, parties or attorneys may contact him or her with questions or concerns. The hearing officer cannot provide legal advice, though, or help either party present their case. The hearing officer expects that the primary means of communication will be email for everyone who has and uses an email account. All communications to the hearing officer, from attorneys or from parents if they are representing themselves, must be shared with the other side. One-sided communications with the hearing officer are strictly prohibited so the hearing officer can remain neutral. This is very important. It would not be fair to a party if the other side was having conversations with or giving information to the hearing officer. For that reason, the hearing officer will require that all communications between him or her and the attorneys or parents representing themselves be in writing and copied to the other side or through telephone conference calls.
Here are more frequently asked questions. What do I call the hearing officer?
Due process proceedings are formal, and certain decorum is necessary to ensure respect for the process. It is appropriate to call him or her Hearing Officer Smith or Mr. Smith, Hearing Officer Jones or Ms. Jones, or you may simply call him or her Hearing Officer.
Why does the school district automatically get an attorney, but parents do not?
In Pennsylvania, all organizations, like associations or companies or school districts, must be represented by an attorney in legal proceedings. Individuals such as parents can represent themselves and do not need an attorney. And unlike in a criminal case, there is no right to an attorney in a due process hearing. Parents decide for themselves whether to have an attorney represent them or not. The ODR website and the procedural safeguards notice you received from the school lists organizations that may be able to help parents find attorneys to represent them. Hearing officers cannot award attorney's fees, but it is possible for parents who are successful in a due process hearing to seek recovery of some or all of their attorney fees from a court after the case is over. Parents are also entitled to have an advocate, family member, or other knowledgeable person assist them and give support. But parents representing themselves must do the job themselves. They cannot have anyone else present their case for them. What's next? Once the hearing has been scheduled, the parties should begin to prepare for the hearing as soon as possible, since there are requirements for disclosing evidence to the other side before the hearing begins. The next video in this series will address preparing the evidence in your case through witnesses and exhibits. One last word. If you have questions or concerns about your due process hearing, do not hesitate to contact the hearing officer by sending an email message with a copy to the other side or by asking to schedule a conference call. The hearing officer understands that many people, especially parents representing themselves, are unfamiliar with the legal process. Hearing officers are always ready to answer questions and to help clarify anything that is confusing. Hearing officers cannot, however, give legal advice or help the parties present their case. Summary. In this first video in this series, we talked about pre-hearing matters. Those include an overview of due process, the roles of the participants and ODR, important timelines, and communicating with the hearing officer. The second video will address how to prepare evidence for the hearing, and the third and fourth videos will address the hearing itself.
For more information, please contact the Consult line or the Office for Dispute Resolution.